Greetings and welcome. My name is Russell Paul Arthur. I am the creator of Grace Sovereignty Academy and a certified practitioner of sovereign law. And in this video presentation, I'm going to share with you some important information about a sovereign document and procedure known as the Private Estate Trust. The Private Estate Trust is a sovereign document and procedure that secures the equity and rights of our life and estate into a private trust arrangement so that we can operate in the public domain as a free and independent sovereign, with the equity and rights of our life and estate protected from public liabilities and without placing our actual life into legal bondage with the Crown and State. Below on this webpage, you can view the actual Private Estate Trust document to get a more in-depth understanding of how we structure the terms and conditions of operating within the public domain through a private trust as a sovereign. And if you want to learn more about how you can achieve personal sovereignty to benefit your life moving forward, then please do register for a free, live and interactive webinar with me, where together we shall do a deeper dive into sovereignty and how Grace Sovereignty Academy can teach you the knowledge, skills and lawful procedures to transition from citizenship to sovereignty. So let's jump straight into this mini presentation where you shall learn about the document and procedure known as the Private Estate Trust. And I begin with this preamble that gives you clarity and reasoning as to why a sovereign man or woman needs to create a private estate trust. As part of a transition from citizenship to sovereignty, we start the transition to sovereignty with a sovereign document and procedure known as the Declaration of Status. The Declaration of Status we issue to the highest offices of the Crown and State to rescind and cancel citizenship, and to assert our sovereign authority and rights to live free and independent from the Crown and State. In the Declaration of Status, we establish our sovereign authority to self-determine, self-direct and self-govern our own life and estate in accordance with our own free will and conscience. In the Declaration of Status, we notify the Crown and State of several important corrections: that we stand on this earth and in this world as a living man or woman who exists and operates in the private with sovereign authority that is free and independent from the Crown, State and its public domain; that we as a living man or woman have severed the surety relationship that we once had to the corporate legal person and entity known as the citizen, and therefore as a sovereign we are no longer liable for anything done in the name of the citizen. In the Declaration of Status, we inform the Crown and State that we now come forward as the sole heir and living beneficiary of our life and estate, with the intention to claim and hold all the equitable interests of our life and estate as they are currently contained within a public trust that is currently held and administrated by HM Treasury of the State. For that reason, we must create a private estate trust to claim, own, hold and manage those equitable interests. Because once we have cancelled citizenship and have corrected our status to live as a free and independent sovereign, we can no longer operate as a citizen of the state, and we can no longer operate in the public domain as a sovereign, as this would place our life back into legal bondage with the Crown and State. As a sovereign man or woman, we simply cannot engage in any commercial, corporate or public enterprise in the name of the citizen or in our sovereign capacity, as this would bind our life back to all the legislations, acts, statutes, rules, regulations and codes of the public domain. And this would effectively undo our status correction. We therefore need a way to continue operating in the public to access the public services that we do need to facilitate our life. Public services such as energy, banking, insurance, business, commerce, etc. But as a sovereign, we can operate in the public domain. We can access those public services through the use of a private estate trust. As a sovereign, we can claim and convert the equity and rights of our life and estate, as they are wrapped up in the citizen, into a new private trust arrangement that we control as a sovereign in the private. Once we have secured all the equitable interests of the citizen into a private estate trust, we can then contract with and access all the public services that we need through the private estate trust, without creating any legal bondage or public liabilities to our actual life as a sovereign, where all public matters that concern our life and estate within the public domain will be contained within the private estate trust and will be dealt with through the private estate trust. And here is how it works. We begin with taking an overview look at the private estate trust. Once we have corrected our status to become sovereign who operates independent from the public domain, we can create a private estate trust to claim and contain the value and rights of the citizen into a private trust arrangement that we control as a sovereign in a private domain. We can claim and contain the value and rights of our own life and estate, as well as the equity of all the estates of our entire genetic lineage that have been consolidated and contained by HM Treasury throughout the centuries. The private estate trust is created as a sacred trust between you as a sovereign and the divine source of creation, and where the trust is sacrosanct. This means it is beyond alteration and interference, and therefore cannot be breached by any other authority in this world. The private estate trust is designed to own and hold the equitable interests, the value, rights and benefits of the citizen as private property of the trust that is protected by trust law. By securing the equitable interests of the citizen into a private estate trust, we practically and lawfully reinstate and convert the citizen into a private trust. The private estate trust is created as an unincorporated and non-statutory trust. The trust is not registered in the public domain, is not registered as a tax-paying entity, and is established under a special and private trust arrangement governed by the maxims of equity and trust law, where all the equitable interests of the citizen are secured into a non-taxable trust. Now, all nation states are bound by an act known as the Judicature Act of 1873, which is still in operation today, and where they must honour the private and untaxable nature of this type of trust, where as such, the public authorities cannot violate or diminish the intention and purpose of this untaxable trust arrangement. We, as the living man or woman with sovereign status, will be positioned as the living beneficiary of the trust. This means we can benefit from the equitable interests of the citizen in a private capacity and without any legal bondage or liabilities to any tax codes. The private estate trust is issued to the Secretary of HM Treasury, who is appointed as the custodian and trustee of the trust. We do this because HM Treasury holds and manages the Crown Commonwealth of the state and controls all the public trusts of all the lives and estates of all the citizens that are functioning in the debt-based financial system that is funded and managed by HM Treasury. And although we lawfully convert the equity and rights of the citizen into a private estate trust, the public trust of the citizen will still be in operation as an open and active account at HM Treasury, with active and outstanding debts that are linked to bank accounts, public service accounts, loans and mortgage contracts, so on and so forth. These open accounts of the public trust of the citizen exist on the debtor's side of a double ledger, with HM Treasury as the custodian and trustee of our new private estate trust that now holds the equity and rights of our life and estate as wrapped up in the citizen. We can then instruct HM Treasury to utilise the private equity of the trust as a credit to discharge, settle and extinguish all debts that are outstanding and ongoing that exist on the debtor's side of the public trust account. In this new private estate trust arrangement, we have achieved several important outcomes. We have removed the value and rights and benefits of the citizen out of the public venue and jurisdiction and into a new private and sovereign venue and jurisdiction. All the equitable interests of the citizen have become the private property of the private estate trust, and where the private property is now protected by the terms of the trust and trust law. This means all public agencies and authorities will have no authority or right to use or appropriate the equitable interests of the citizen for their own use and means without expressed permission from the trust. And we have repositioned ourselves as a sovereign authority and living beneficiary who benefits from the value of our life and estate as contained by the HM Treasury. We have secured the value of our life and estate in the private estate trust, and where that value is private equity that can be used to settle all public debts in the name of the citizen. The private estate trust is established in accordance with trust law and the law of equity that provides remedy to correct a mistake and right a wrong. Because it was wrong, the Crown and State used deception and forced compliance to secure the value and rights of our life and estate into a public trust arrangement that is controlled by the HM Treasury and administrated by the state. And on the basis that we did not know that our life and estate was placed into legal bondage with the Crown and State at the point of birth registration, and on the basis that we no longer wish to participate in this fraud, we are now looking to correct the mistake. We are utilising trust law and the law of equity to now come forward with sovereign authority to take back control of our own life and estate, to now assert a paramount claim to the equitable interests of our life and estate as the sole heir, living beneficiary and rightful owner of our life and estate. We are now taking active steps to remove the value and rights of our life and estate from the public trust arrangement and to secure those values and rights into a new private estate trust that we now control in the private. In this second slide, we highlight the difference between the citizen who is in a public trust arrangement with the Crown and State and the sovereign who is in a private trust arrangement with the Crown and State. As a citizen of the state, we are in a trusteeship relation with a public trust that was issued and controlled by the Crown and State. In this trusteeship relation, the citizen is liable for all the rules, regulations and tax codes that are attached to all the property of the trust. The equity and rights of our life and estate, everything that we earn and own in our life, is property that is contained in the public trust, and where we all have a public estate that is the beneficiary of this public trust, we all act as a citizen that is a legal person, has been designated as the trustee of the public trust, and where the citizen holds the legal title, responsibility and liability for the trust property, where the Crown and State owns and controls the public trust, the citizen and your public estate. In this public trust arrangement, you act as the citizen, and the citizen is a title holder of everything that you own and earn in the public domain. The citizen is a registered keeper and holder of the value of the trust property, but not the owner. The citizen only has ownership rights to the trust property. This means the citizen owns the rights to the property, but does not own the physical property of the public trust. The citizen is a trustee with legal title, and in accordance with trust law, a trustee can never own the trust property. The citizen is an insolvent debtor in a bankrupt banking monetary system, and the citizen as a legal person and fiction in law has no real status and standing to own any property in this world. Instead, the citizen has the legal title and rights to use, possess, sell and profit from the property as a legal franchise of the Crown and State. In this public trust arrangement, the living man or woman is a bonded surety for the citizen and legally obligated to handle all matters and settle all the bills for the citizen. Previously, at birth registration, we all abandoned our life and estate to the Crown and State, and where the state became the default executors of our life and estate. However, once we have corrected our status and have severed and separated our actual life as a living man or woman from the legal fiction known as the citizen, we are no longer a bonded surety for the citizen. When we become sovereign, we can come forward as the sole heir and living beneficiary of our life and estate, with the full standing, absolute right, and paramount claim to own, hold the value and rights of our life and estate, free and independent. With our corrected status as a sovereign, we now have the indisputable and lawful right to claim, own, hold, and control the equitable interests of our life and estate as contained in the public trust. As the sole heir and living beneficiary of our life and estate, and in accordance with the law of equity, which is doing what is right and fair, our rightful claim to the equitable interests of our life and estate are paramount and prior to the claim of the Crown and State. As the sole heir and living beneficiary of our life and estate, we can now claim all the equitable interests of the citizen as held in public trust, and then secure all those equitable interests into a new private estate trust. We have the authority and rights to transfer the equitable interests out of the public trust and into the new private estate trust, because we have asserted our natural birthright as a sovereign executor of our life and estate. HM Treasury are managing the public trust account, and so by appointing HM Treasury as custodian and trustee of our new private estate trust, we can request HM Treasury to use the private equity that we have secured in the private estate trust to settle all debts that are still active and open in the public trust. Because HM Treasury cannot close the accounts and contracts of the public trust until they are settled and balanced out. In this new private estate trust arrangement, we are doing what is known as an estate in reversion. Once the public trust account has been fully settled and squared by HM Treasury, who administer the public trust account, we can then request HM Treasury to return back to us the reversionary interests of our life and estate. Reversionary is a word that means the return of something that is owned by another. Therefore, an estate in reversion is where the interests of our life and estate are returned back to us from HM Treasury, who shall no longer remain in the control of our life and estate as part of the Crown and State. We claim the equitable interests of our estate in the form of equity that has not been designated or converted into a tangible form or a determined value such as money, property, or hard assets. We cannot receive money, property, or hard assets from the Crown and State because these are all part of the Commonwealth that is under the military occupation of the Crown. The money, property, and hard assets are being administrated by the Crown in accordance with usufruct law, which is a law that permits the use of someone else's property. The Crown is utilising the money, property, and hard assets of the nation as security for the purpose of servicing the ongoing debt management of the nation. So we clearly state that we are claiming the equity of our life and estate as an estate in reversion, but only during the time of the military occupation and debt administration of the nation state. Once the military occupation and debt administration is over, as the sole heir and living beneficiary of our life and estate, the tangible assets and property must revert back to us as the true owner. In the meantime, with the private estate trust arrangement, we have secured and control the equity and rights of our life and estate, but we do not own the tangible assets and property of our life and estate as contained in the Crown Commonwealth. This means we can receive and control the interests of our life and estate in the form of equity. Equity meaning value. This happens when we claim and transfer the birth certificate into the new private estate trust. We claim the equity and rights of our life and estate. Once the public trust account has then been settled by HM Treasury, using the equity contained in our new private estate trust, the net value of our life and estate, the remaining equity, would be the balance left for us to claim as the equitable interests that belongs to us as the sole heir and living beneficiary of our life and estate. So to summarise, in this new private estate arrangement we achieve 6 important acts. We have converted the equitable interests of the citizen, our life and estate, into the capacity of a private estate trust. We have effectively collapsed the public trust. We have removed the value and rights of our life and estate out of the public venue and jurisdiction of the Crown and State and into a new private and sovereign venue and jurisdiction of the private estate trust. We also become the living beneficiary and true owner of the equity and rights of our life and estate as a living man or woman with sovereign status, as opposed to being a citizen and trustee in a public trust arrangement. The public agencies and authorities will be acting as trustees to manage this new private estate trust, and they will carry all the legal responsibilities and liabilities to settle all public matters. We can then contract with the public services that we need to facilitate our life via the private estate trust, without creating any legal bondage or liability between us as a sovereign and the Crown and State. That now brings us to the subject of the birth certificate. The birth certificate is a seminal document that secures the equitable interests of our life and estate as contained in the public trust. When our life was registered to the Crown and State, we unknowingly handed over our life and estate to the authority and control of the Crown and State and formed a public trust arrangement with the Crown and State. The birth certificate was issued to us as a legal bond that represents the value and rights of our life and estate. When we received the birth certificate, we assumed the role of the trustee and legal title holder of the citizen, which we know is state-owned property. And along with that title holding position came all the legal responsibilities and liabilities attached to the birth certificate. Once we have corrected our status to stand as a living man or woman with sovereign authority, we can accept and claim the birth certificate as a gift in equity. We can accept and claim the birth certificate as a sovereign because the interests that are vested in the birth certificate do rightfully belong to us as protected by the law of equity. When we accept and claim the birth certificate, we also accept and claim the equitable interests of our life and estate as vested in the birth certificate. Once we accept and claim the birth certificate as the living man or woman, we lawfully and effectively collapse the public trust from which that birth certificate represents. The Crown and State issued the birth certificate as property of a public trust. They appointed the citizen as trustee and holder of the legal title of the birth certificate, and where our estate, as managed by HM Treasury, is what holds the equitable title of the birth certificate. Once we accept and claim the birth certificate as a sovereign, we merge the legal title and the equitable title of the birth certificate. We then hold the absolute title of the birth certificate free and clear of any other interests or claims. All trust arrangements do cause a split in a title of trust property so that the property can be arranged in a management structure that involves a trustee and a beneficiary. However, when one person accepts and claims the property of the trust, the two titles merge and the trust arrangement ends. Once the sovereign is the absolute title owner of the birth certificate, The sovereign has the absolute right to transfer the birth certificate into a new private estate trust. Once the birth certificate is secured in the new private estate trust, the birth certificate becomes private property of the trust. This means the private estate trust then owns, holds and manages all the equitable interests, all the value and rights of the citizen of your life and estate as vested in the birth certificate as managed by HM Treasury. In this new arrangement, the trust dynamics have reversed and changed. In this new trust arrangement, the sovereign is positioned as living beneficiary of the trust. In accordance with the maxims of equity, the beneficiary is the true beneficial owner of the trust property. The birth certificate is a bond to the equity and rights of your life and estate as managed by HM Treasury. This means once you have secured the birth certificate in the private estate trust as the living beneficiary, you become the true owner of the equity and rights of your life and estate as managed by HM Treasury, whereby you as the living beneficiary can receive benefits from the trust in a private capacity and equitable nature that is free from the tax codes of the public domain. This means the sovereign can receive tax-free income. This means the sovereign can hold, occupy, use and enjoy property free from any tax implications. In the new private estate trust arrangement, we appoint the Secretary of HM Treasury as the custodian and trustee of the private estate trust. The trustee will be authorised to hold and manage the legal title of the trust property for and on behalf of the sovereign. The reason that we appoint HM Treasury as the custodian and trustee of the private estate trust is because HM Treasury are managing the public trust that contains the value and rights of our life and estate in their system in the name of the citizen. The public trust will have outstanding and ongoing liabilities and debts connected to the public service accounts and contracts that are open and active in the name of the citizen. For us to stand as true sovereigns that are wholesome and free from any legal bondage and debts to the Crown and State, we must uphold and perfect our new standing by settling all outstanding and ongoing debts of the public trust account. And this new private estate trust arrangement is all done in accordance with trust law and the law of equity that provides a remedy to correct a mistake and right a wrong. As a living man or woman, we are the creative life force that created all the wealth in the name of the citizen. And therefore, it is only right that we take hold and control the wealth in our capacity as a living man or woman. We were also deceived and defrauded by the Crown and State, who took possession of our life and estate at the point of birth registration. We were unknowingly operating as a citizen with diminished status and liability as a trustee, and now we are coming forward to correct that mistake. Now that we have discovered the fraudulent defect of the citizen and have corrected our status, we now come forward as the sovereign authority and sole heir and living beneficiary of our life and estate, and we have the right to claim the equitable interests of everything that we have earned, created and built in the public domain through the citizen, and we can transfer that wealth into the new private estate trust. In this third slide, we shall examine how, once the private estate trust has been established to secure the equitable interests of our life and estate as private equity of the trust, we can then use the private equity to settle any debts and charges attached to any public instruments that are issued in the name of the citizen. Right now, the equitable interests of your life and estate are secured in a public trust arrangement with a HM Treasury account that operates on a creditor-debtor principle. The HM Treasury controls the funding of the public domain. The HM Treasury controls a double ledger system of banking, finance and commerce that operates with creditors and debtors. The public trust that contains your life and estate has a double entry ledger. This double entry ledger has a public side and a private side. The private side of the ledger holds the private equity of your life and estate. The public side of the ledger holds the public debt of the citizen as a debtor in the financial system. The private equity of your life and estate is what backs and securitizes the debt that you earn, own, and owe in the public as a citizen. Every citizen of the state is operating with an open and active double ledger account that is being administered by HM Treasury, and where all the public agencies of the Crown and State are authorised to create and issue public instruments in the name of the citizen and charge debt to the citizen. And even when you secure the equitable interests of your life and estate into the new private estate trust arrangement and request that HM Treasury settle all outstanding debts on the public trust account, the public trust account will still be open and active because it contains all your personal and business interests as open and active accounts in the public in the name of the citizen. This means you will still be receiving public instruments in the name of the citizen within the public domain. Every document, bill, invoice, contract, title, claim, charge, debt, bond, certificate, everything that is issued from a public agency in the name of the citizen is a public instrument with a liability attached to that instrument. In particular, financial instruments such as bills, charges, invoices, and promissory notes are debts issued in the name of the citizen. All these instruments are placed into the public trust. The instrument is then sent to the citizen as the designated trustee of the trust, who is entrusted with the legal title as trustee to settle the obligations of the instrument. In the public trust arrangement, you as a citizen have been designated as a trustee of the public trust, and you hold the legal status, title, and responsibility of settling any charges attached to any financial instrument that is issued in the name of the citizen. Whenever you receive a financial instrument, whether that be a tax bill, court case, claim, traffic ticket, bill, anything that you receive that is a financial instrument in the name of the citizen, you also become the trustee in the matter, with all the legal obligations to settle the amount that is charged on the instrument. And you pay and settle the debt with a fiat currency, which is another debt instrument, and therefore you discharge the debt with another debt. And that is because we do live in a global debt-based banking monetary system where you can only charge and discharge debt, and where this system has been set up in the public domain with the citizen as a debtor of the financial system. When debt is issued in the form of a financial instrument, this immediately creates an outstanding amount that must be settled to balance the public trust account. Financial instruments are often negotiable instruments that are governed by the Bills of Exchange Act 1882. When a bill, which is a charge or debt, is exchanged in commerce from one party to another, from a creditor to a debtor, the bill represents a promise or order to pay a fixed sum. Your life and estate, as contained on the private side of the public trust, has the value of your labour and property, and this value is what makes you a creditworthy asset of the Crown and State, and where essentially your life and estate is the credit that backs all the debt created in the name of the citizen. Your creditworthiness as a living man or woman has always been the bonded surety for the citizen, and where your signature applied to any contracts in the name of the citizen has been the endorsement and security for the debt borrowed and owed in the name of the citizen. This means the value of your life and estate is what underwrites every financial instrument that is issued from a public agency in the name of the citizen as part of the public trust, where the value of your life and estate is a credit that underwrites the debt of the citizen. Financial debt instruments are issued from the public side of the public trust in the name of the citizen as a debtor and liable party, and on the private side of the public trust is the credit of your life and estate that underwrites the financial instrument. This means every financial instrument issued in the name of the citizen has a face value, which is a public debt, and has an underwriting value, which is a private credit. For example, a bill that charges a face value of £50 is the public debt. It also has an underlying value of £50, which is the private credit, where effectively the bill has a combined value of £100 in total. Before you correct your status to become sovereign and whole, your life is the bonded surety for the liabilities and debts of the citizen. Once you have corrected your status and severed your attachment to the citizen, you are no longer liable for the liabilities and debts of the citizen. This means the public authorities cannot look to you as the living man or woman to settle any financial debt instruments. You as a living man or woman and the former surety to the citizen are now fully exonerated from all the liabilities and debts of the citizen. As part of the new private estate trust arrangement that has secured the interests of the citizen within the trust, you shall demand that all public authorities hold the citizen as the surety that is liable for any and all financial debt instruments issued in the name of the citizen, and where they must now charge the public trust account to settle the debt and not charge you as a living man or woman. Also, public instruments that are issued in the name of the citizen in a form of a corporate, commercial or legal contract, even trusts, titles, bonds, court orders, tax claims, and where the citizen is named as the liable party, these can also be secured and neutralised in the private estate trust arrangement. And what I need you to realise is this: it does not matter if you, as the citizen, respond, reject, challenge or remain silent to any claim and liability that is issued in the form of a public instrument. The mere fact that you receive, accept and hold the instrument as the trustee means that you are legally liable and responsible to settle the matter. However, you as a sovereign can accept and secure all public instruments into the private estate trust, where you effectively withdraw the instrument from public use and neutralise any claim and liability that is attached to the instrument. We can appoint any public authority that has issued a public instrument in the name of the citizen as a trustee to receive and settle the instrument on the public side. Each time a public authority issues a public instrument in the name of the citizen, they are creating a new trust arrangement. Once we have converted the citizen into the private estate trust, we can rightfully secure any public instrument issued by any public authority as property of the private estate trust. Each time that we receive a financial instrument in the name of the citizen, we as a sovereign can claim the underwriting equity that is embedded in the financial instrument as a deed and gift in equity. When accepting and claiming instruments as the living beneficiary, we merge the titles, we merge the legal and equitable title of the instrument and collapse the trust arrangement. We can then secure that instrument into the private estate trust as private property of the trust. This means we have removed the instrument from public use, and where it becomes a private instrument that is now managed as a private matter by us as a sovereign in a private domain, where the instrument is privatised and protected as private trust property. When the private equity of a financial instrument has been secured into the new private estate trust, the private equity of that instrument can be used as private credit to discharge the public debt attached to the same instrument. We can use the private equity that underwrites the instrument to discharge and neutralise the face value debt of the same instrument that is charged to the citizen. For example, When a bill, claim, fine or penalty is issued in the name of the citizen, we can now claim the private equity that is embedded in that instrument to settle the debt that is charged on that instrument. If there are any charges or debts attached to an instrument, we can request the appointed trustees to perform their duties as a trustee to settle all charges or debts and to neutralise and extinguish the matter on the public side. We shall provide the trustee with authorisation to use the private equity that is embedded in the instrument as a private credit to settle the public debt attached to the instrument. In this next presentation slide, I now show you an example of how a sovereign can create a private trust to secure and access public services in the public domain without creating any legal bondage or liability to the Crown and State, and where any liabilities, such as claims or debts, that arise from our use of the public service are contained and settled by and through the private trust. In this example, I show you a general services trust. We can form a private trust arrangement and binding contract with the council, with the local government, to obtain general services. The councils are charged with providing general public services such as water, sewage, fire departments, law enforcement, medical, street lighting, waste collection, and whatever else it is that they do. Once we have corrected our status to become sovereign, we can no longer accept these public services in the name of the citizen, and we can no longer accept them in our sovereign capacity as a living man or woman, because this would bond us back to the Crown and State. With the new General Services Trust, we appoint the leading authority and public official of each council office as a trustee of the trust, and this will typically be the Chief Financial Officer or Executive Director. The public official at the council offices is also a public trustee who is charged with overseeing the public trust account of each citizen in relation to the use of general services. You as the sovereign will be positioned as the living beneficiary of the General Services Trust, and you will be entitled to receive the benefits of the general services that are now contained in the trust without creating any legal bondage or liability with the council, Crown and State. We can appoint a trustee at the council as the custodian of the General Services Trust. The trustee will also become a special deposit agent who is tasked with handling and settling all public instruments and liabilities, all claims, charges and debts that are issued from the council in relation to the general services. We can request that the council open a unique special deposit account that will be used by us to deposit a birth certificate and surety bond on special deposit in the vault and treasury of the council. The birth certificate and surety bond will be private property contained in the General Services Trust. The birth certificate represents the equity and rights of our life and estate, and the surety bond is bonded to the private estate trust that is being held and managed by HM Treasury. This means the General Services Trust will contain the private equity of our life and estate as secured with HM Treasury. We can instruct our trustee at the council to use the private equity of the General Services Trust to settle any public claims, liability, charges and debts in relation to our use of the general services. The trustees of the General Services Trust will be informed and instructed that the citizen has now been claimed and converted into the private estate trust, and where the general services are now public matters to be settled through the General Services Trust. The General Services Trust is a document package and procedure that we create and issue to the council to demonstrate, substantiate and prove that we are no longer a citizen of the state and no longer under the authority of the local council. We are informing the council that we have sovereign status and standing and now come forward as the sole heir and living beneficiary of our life and estate in the capacity of a living man or woman who exists and operates in a private and sovereign venue and jurisdiction that is not part of the council's corporate legal venue and jurisdiction. We establish the fact that we hold superior status and standing than the council, who are nothing more than corporate and legal fictions with no real status and standing on the land of earth. We should also issue a certified copy of the oaths of office to the trustee for the General Services Trust to remind the official that they do have a duty to act and settle all public matters. If the appointed trustee ignores the new trust arrangement and instead continues without your permission to unlawfully monetize the citizen by issuing bills and debts in the name of the citizen, you will simply accept and claim those bills and charges as deeds and gifts in equity and then return the bill and charge back to the appointed trustee at the council to settle and neutralise the bill and charge using the private equity of the private estate trust. This brings us on to the fifth slide. In this presentation slide, I give you an example of how a sovereign can create a private trust to contain the use of a vehicle on the public roadways without creating any legal bondage to the Crown and State, and where the liabilities of using a vehicle on public highways is contained and settled by the private trust. To operate a vehicle on public highways, we do need a driver's licence, public insurance, MOT, road tax, and to register the vehicle with the DVLA, the Driver and Vehicle Licensing Agency. You simply cannot use a vehicle on public highways without all of the above, and for many reasons that are mainly focused on public safety and order. If we attempt to use a vehicle without a driver's license, insurance, and not registering the vehicle with the DVLA, then when stopped by the traffic police, the vehicle will be impounded and we will be detained. At the moment, we all have a vehicle that is set up in the name of the citizen as the registered keeper and driver of the vehicle. However, we can no longer operate the vehicle as the citizen and can no longer present ourselves as the citizen when driving the vehicle, as this would bond us back to the venue and jurisdiction of the Crown and State. On the basis that we have converted the citizen into a private estate trust, we can now secure our use of a vehicle as a sovereign on the public highways into a new private carriage trust arrangement. The private carriage trust will be an extension of the private estate trust. As a sovereign man or woman, we can claim and secure all the interests of the citizen and vehicle into the private carriage trust. This means you, as a sovereign, can claim the DVLA registration, driver's license, road tax, MOT, and vehicle insurance policy, and anything else to do with driving the vehicle on a public highway, and place these interests as private property that belongs to the new private carriage trust. You, as a living man or woman in your sovereign status, will become the living beneficiary of the private carriage trust and therefore the true owner of the trust property. You will then appoint all public officials related to the use of a vehicle on public highways as the trustees of the private carriage trust. From that point onwards, the private carriage trust will handle all public matters and settle all public liabilities concerning your use of the vehicle as a sovereign. You will create and issue certified copies of the private carriage trust to the 4 public agencies that deals with drivers and vehicles on a public highway. These will be the Driver and Vehicle Licensing Agency, the DVLA. The DVLA is the main government body that is responsible for driving licenses, vehicle registration and driving records. Then we have the Motor Insurance Database, the MID. The MID holds the insurance details of all vehicles in the UK and where the police can access this database to check the insurance of specific vehicles. Then we have the Road Policing Unit. Every police force in the UK has a road policing unit that patrols motorways and major roads, enforces traffic laws, responds to crashes and dangerous driving, and stops unsafe and uninsured vehicles. And that brings us to the insurance company. This will be the insurance company to which you have a current insurance policy for the vehicle. Now, these four public agencies are interconnected when it comes to enforcing, regulating and ensuring the use of a vehicle on the public highways. And we must inform these public agencies that the new private carriage trust will handle all the public matters and settle all the public liabilities concerning your private use of the vehicle as a sovereign on the public highways. We shall also appoint the highest office holders of these public agencies as the trustees to handle and settle any public liabilities, any claims, charges and debts that arise from our private use of the vehicle. Now, as part of becoming sovereign, you will create a power of attorney to become a private agent in the capacity of a living man or woman with your authority and powers to act for and on behalf of the citizen, which is a legal person, in all public matters. As a private agent for the citizen, you will be authorized to possess and use the vehicle of the citizen. You can present yourself as the private agent of the citizen, where you, as the private agent, have no legal responsibility or liability for the citizen. Should you get stopped on a public highway by the traffic police, you can then present yourself as a private agent for the citizen who has the power of attorney to act as the citizen and use the vehicle in your private capacity. You can inform the traffic police that everything has been lawfully and legally constructed into a private trust arrangement. You can inform the traffic police that you have claimed the driver's documents in your rightful capacity as the living beneficiary. And you can present all the new trust documents to the police that you will keep as certified copies in your vehicle. Now, of course, the traffic police will not be able to recognise or process the private carriage trust information because it is beyond their mind programming and understanding of the law. The traffic police are likely to reject and ignore the information that you present them, and they will continue and proceed to treat you as the citizen, in which case they will be acting in ignorance of the law and in ignorance of the facts of the matter as they are presented to them. And this does not change the fact that you have lawfully converted all matters related to driving the vehicle into a private carriage trust that protects your life as a sovereign from any legal bondage and liabilities in the matter. In any instances where the traffic police or any other law enforcement officer has issued a public instrument, has issued a fee, fine, penalty or charge in the name of the citizen related to the use of your vehicle on the public highways, then this public instrument will be issued in the name of the citizen, and you as a sovereign will then accept and claim this public instrument as a deed and gift in equity. You can then secure the deed along with its private equity as a private instrument and private property that is contained within the new private carriage trust. You can then send the instrument back to the appointed trustee of the private carriage trust and request that the trustee use the private equity of the trust as a credit to discharge the debt on the public side of the instrument. With the private carriage trust arrangement, this means you as a living man or woman can travel through the public domain without being liable for any public liabilities, without being liable for any claims, debts or charges, and where you can maintain your sovereign status and standing free from legal bondage and liability. In this final presentation slide, I now show you how all public services can be contained in a private trust so that we can access and benefit from the public services as a sovereign without creating any legal bondage or personal liability with the Crown and State. We can secure the equity and rights that we have vested in a public service into a private trust that holds the equity and rights as private property that we manage and control in the private. We can then appoint the public service providers as trustees with legal title who are charged with managing the private property in context of the public account. We can then transfer all the public liabilities, all the claims, charges, fees, penalties and debts over to the trustee who has a duty to settle the liabilities. We can take the position of being a living beneficiary of the trust in a private and sovereign capacity and receive benefits from the public service without any liability or legal bondage, and whereas per the maxims of equity, as the beneficiary, we are the true owner of the trust property. For example, we can convert all the public interests that we have with the Inland Revenue into an Inland Revenue Trust. The Inland Revenue Trust will contain and settle all tax claims, charges, debts and penalties issued from the Inland Revenue in the name of the citizen. We can return any instruments back to the Inland Revenue via the Inland Revenue Trust and request the appointed trustee to settle the instrument using the private equity of the trust. For example, we can convert all the public interest that we have with the energy companies such as gas, electric and water into a utility service trust. The utility service trust will contain and settle all the claims, charges, bills, debts and late penalties that are issued from the energy companies in the name of the citizen. We can then return any financial instruments back to the energy company and request the appointed trustee to settle the instrument using the private equity of the trust. Here is another example. We can convert all the public interests that we have with the finance and mortgage companies into a financial debt trust. The financial debt trust will contain and settle all debts in the name of the citizen. We can then request the appointed trustee of the finance company to settle the debts using the private equity of the trust. And we present each private trust as a self-executing contract to place the trustee into a contractual obligation to deliver the public services on a private basis as per the terms of the trust. Each private trust will privately contract with a public service provider and shall appoint a specific trustee to carry out all the duties of handling and settling all matters regarding the public service, and these duties will be stipulated as terms of the trust. Now, typically it is the head corporate official who is in charge of a specific public service that we appoint as the trustee. For example, with a utility service trust, we shall appoint the chief financial officer of the utility company as the trustee. The CFO is the one who oversees the finances and customer accounts of the utility company. And even though the corporate officials are public in character, they will be appointed as trustees in a private nature with fiduciary duties to hold and manage the affairs of our life and estate as it pertains to the public service. The trustees will be appointed in personam, and where the liability and responsibility for the trust arrangement will be attached to the trustee as a living man and woman and not the fictional corporate role they play. Each trustee that manages a private trust will be entrusted with the duty to settle all liabilities associated with any instruments, any claims, charges or debts, and where the trustee does have a legal responsibility to settle all claims and charges made against the service as it is contained on trust. Each trustee will be able to access the private equity of the private estate trust as a private credit that the trustee can use to discharge and extinguish any liabilities attached to any instruments that we shall return back to the trustee. And this is all done in accordance with trust law and the law of equity and the maxims of equity, especially the two following maxims. Here is the first one. Equity sees that as done what ought to be done. This means when seeking remedy in law to correct a mistake and right a wrong, so long as we have irrefutably demonstrated proof to substantiate the claim that we are making to get the remedy, then the equity in the matter is considered as being done and fulfilled, even before it has been actioned and even when those responsible for providing the remedy fail to provide the remedy. As a sole, heir and living beneficiary of our life and estate, we do have the absolute authority and rights to transfer the equity and rights of our life and estate, where a public service is concerned, into a new private trust. In equity, that is considered right and done. As a sovereign, we have severed and separated our life from the legal person in fiction known as the citizen. And so we are no longer responsible or liable to settle the public matters of the citizen. In equity, that is considered right and done. As a sovereign, the equity of our life and estate is embedded in any public instrument that carries a charge and debt in the name of the citizen, and where we have claimed the interest of the citizen into a private estate trust. Therefore, we have absolute authority and rights to claim all public instruments and return them back to the issuer to settle on the public side. In equity, that is considered right and done. Then we come to the next maxim of equity. Here is the maxim. Equity will not allow a trust to fail for want of a trustee. If there is no trustee, or a trustee fails to accept or respond to the role of a trustee, even then, if the trustee still holds the trust and holds the trust property and legal title, then they will still be considered the trustee. Even if an appointed trustee disclaims the position of trustee, the private trust arrangement itself will not fail or end. The equity and rights of the trust will still remain secured as private property that is protected by the terms of the trust. If an appointed trustee disclaims the position of trustee, and yet that person is the only person that holds the role, position and authority that is suitable to access and manage the public service in relation to our private trust, we can then seek remedy in a court of law using the law of equity to force the person to accept the role of trustee. If an appointed trustee disclaims the position of trustee, we can also appoint another trustee to handle the private trust. In these new private trust arrangements, the Crown, State and its public agencies and authorities, they will no longer have the authority or right to claim, control, charge or use the private property of the trust without our express permission. This means they can no longer have authority and control over the interests of the citizen once converted into the private trust, where it is unlawful and illegal for them to trespass against, violate, secure, use or claim the interests of the citizen that are now protected by trust law and the law of equity. However, because the public authorities are mind-conditioned, indoctrinated and programmed actors that act with ignorance of the law and in arrogance of their position, and where these public authorities will lack the true understanding and awareness of how our private trust is structured to protect our life and estate from the public domain, they will unfortunately continue to hold the citizen liable for any personal and business activities that we conduct in the public domain. As far as the public system is mistakenly concerned, your life and estate is still being administrated in the name of the citizen as part of the public trust, where the machine will continue to plough forward on autopilot and in error, until the operators of the machine wake up and realise the errors of their way. When appointing public authorities, we are creating trust indentures. Indenture means to form a contract that covers the terms and liabilities of an obligation or transaction. When issuing trusts and instruments to public authorities, we are conveying all legal titles and liabilities to the public authorities as trustees of the trusts. All public authorities that we appoint as trustees will have a duty and responsibility as public trustees to settle all liabilities made against the citizen in relation to the public trust, and where that duty is in the capacity of a trustee that is bound to perform in accordance with trust law, and they must maintain and protect the public trust. This means each trustee will have a personal liability to settle and close all outstanding liabilities, all charges and debts that are open, active, and have been presented in any instrument that they issue in the name of the citizen, and that we shall return back to them as the trustee so they can settle the debt of the instrument. The trustees will be compelled to protect the trust property and perform their fiduciary duties as the legal title holder of the trust property. And as I mentioned before, all private trusts are formed as self-executing contracts on the basis that a non-response or an improper response from the appointed trustees of the private trust means the trustee has, in accordance with law, given tacit approval and acceptance of the terms and conditions stated within the trust arrangement, or has failed to perform as requested as per their duty as a public trustee in public matters. With all the above in mind, we must still tread with caution and diligence when appointing the public authorities as trustees to handle trust matters. The public system does not have a format or procedure for dealing with unusual and unformatted requests and instructions, and the computer often says no. When executing the private trust arrangements, we must take steady and stalwart action to compel the public authorities to perform as trustees, or we must enforce the liability for lack of performance. The whole purpose of the private trust arrangement is to secure public services into private trusts so that we can continue to access and use public services to facilitate our life while maintaining a status and standing that is free and independent from the venue and jurisdiction of the Crown, State and its public domain. And that brings me to the end of this mini presentation. You now know about the lawful document and procedure known as the private estate trust that secures the equity and rights of our life and estate as contained by HM Treasury into a private trust arrangement that we control in the private and that allows us to access and pay for public services as a sovereign man or woman without placing our actual life into any legal bondage or liability with the Crown and State. And this is a procedure amongst many other procedures that we teach our students inside Grace Sovereignty Academy. So please do review the private estate trust document below this video. And if you are curious to learn more about the transition from citizenship to sovereignty and learn more about how Grace Sovereignty Academy can transform and benefit your life, then please do register for my free webinar. This is a live and interactive webinar where you can discover more about the benefits of sovereignty. And that leaves me to say thanks for being here today. Take care for now.